I'm Donald Donovan. I practice law in New York City. I work at a firm called Debevoise & Plimpton, and my practice is primarily international disputes in U.S. courts and international arbitration tribunals and also international courts. And I also teach at NYU Law School. It's actually a pair of cases. One case was in the International Court of Justice, and it's called the Avena case. And the other case was in the United States Supreme Court, called the Medellin case, and they're very closely related, and I'll explain why. In the Avena case, Mexico brought a claim against the United States in the International Court of Justice. Now, the ICJ, as it's called, or the World Court, is a court that hears disputes only between states, and by states I mean states in the international sense, that is countries, different countries. And what Mexico claimed in that case was that the United States had not provided a right that it was required to provide under a treaty called the Vienna Convention on Consular Relations. And that specific right was that when a national of one state is arrested or detained in another state under this convention, those nationals are entitled to be advised that they have a right to speak to the consul, who's a diplomatic officer of the other state. This is a very important right. The United States takes it very seriously, and so do a lot of other countries, because you can imagine yourself, if you were detained in another country and you thought you had been detained wrongly, or you thought you were in trouble or whatever, you might well want to speak to someone from your home jurisdiction, from your own diplomatic and consular service, who could get you a lawyer, who could explain how things were done in that country. In the case of 52 Mexican nationals who had been detained in the United States, Mexico claimed that they had not been provided this right. And these Mexicans had been detained, had been arrested in cases in which they were accused of capital crimes. And by capital crimes, I mean crimes on which they could receive the death penalty. And so Mexico claimed that these cases should be reviewed in order that the courts could determine whether or not the Mexican detainees, the Mexican defendants, the Mexican folks on death row might have had, the violation might have had an effect on the conviction or sentence. The ICJ, the World Court, held that the United States had violated its obligations in 51 out of 52 of these cases. And it ordered, as a remedy, that the United States review and reconsider these convictions and sentences. And the United States should do so by what the ICJ called means of its own choosing. Somehow in the United States judicial system, these Mexicans on death row should have the chance to demonstrate that the deprivation of these rights had affected their conviction and sentence. So the case then came back to the United States courts. So the second Mexican national who came back to the United States and faced execution was a man named Jose Medellin. He had been convicted in a Texas court of what can only be described as a truly terrible a crime, a murder of two young girls. But he claimed that if the jury had heard certain evidence that had been excluded, he would not have received the death penalty and would have received a lesser penalty. So here was the question before the United States courts, and specifically the United States Supreme Court. He had received all of the process that was prescribed, or the United States courts had determined, the process that he was due under United States law. And he had been in a state court, and he had been in federal courts, and they had reviewed the conviction and sentence. So the question was, even though he had received those rights, did the ICJ judgment require that the United States courts do what the ICJ had ordered the United States to do, which is to review and reconsider this conviction and sentence again in light of the violation of the Vienna Convention on Consular Relations? Now, why might the United States courts have an obligation to do that? I've just said that under United States law he had received, or so the United States courts had held, his rights. Well, the United States is a party to the Vienna Convention on Consular Relations, and that's the treaty under which his rights arose. And there was no dispute about that. The United States was also party to a supplemental piece of the treaty called the Optional Protocol. And the optional protocol provided that if either of the countries to the treaty, either of the states parties to the treaty, had a claim under the treaty, that country could bring it to the International Court of Justice. And that's what Mexico had done. And there had been a full proceeding in the International Court of Justice. The statute, the treaty that establishes the ICJ is called the ICJ statute. And under that statute, Article 94.1, the parties to the statutes say that if the ICJ renders a judgment in a case to which that country is a party, that country will abide by the judgment. So Mr. Medellin argued that the United States had an obligation to abide by the ICJ judgment. Why? Because the United States had agreed to do so. And it agreed to do so in treaties that had been ratified by the process that is prescribed in the United States Constitution by which the United States agrees to treaties. And that includes a process by which the president signs a treaty, but then the Senate, in fact, 2/3 of the Senate, approves the treaty, approves the president's signature of the treaty. And the process that the founding generation set up in the Constitution for approving treaties was specifically to ensure that when the United States entered into a treaty, it had the political support of the representatives, the elected representatives of the American people. So now there's another piece to this situation, which is that in the United States system of government, generally the president and the executive branch are responsible for carrying into effect the foreign relations, conducting the foreign relations of the United States. And the president in this case took the view that whether or not to comply with the Avena judgment was a question that was entrusted to him as president. That is, he took the view that the court, the Supreme Court of the United States, did not have the authority under our constitutional system to give direct effect to the judgment under the Supremacy Clause, but instead that the president had to decide. And the president pointed to his Article 2 authority, and Article 2 is the provision of the Constitution that describes the president's prerogatives, the president's authority, and that included, as I mentioned, the right to conduct the foreign relations. So we had a situation in which Mr. Medellin was arguing in the Supreme Court that the Supreme Court had an obligation directly under the Supremacy Clause and the treaty obligation to give effect to the judgment and send this back to a U.S. court for the review and reconsideration.